In this module, I'm going to provide you with a brief overview of the history of the Canadian criminal justice system, as well as discuss some of its basic philosophical tenets and principles. In particular, I'm going to provide you with the history of the Canadian criminal justice system, primarily focusing on its roots within the United Kingdom. And in the second half of the lecture, I'm going to discuss some of the principles, purposes, and tenets of the Canadian criminal justice system, including its role, purpose, and objectives, and some of its fundamental principles and tenets. Providing a history of the Canadian criminal justice system is important because it provides some context to understand the traditions, the values, the principles, and philosophies of the system. It's firmly rooted in the English system of common law, and providing an overview of these roots within the UK, we understand the evolution of the system, its principles, its tenets, and also about the role that the criminal justice system and the state plays in the maintenance of order and crime control and social control in society. And one of the principal points to come out of this particular historical lecture is that the criminal justice system is a relatively new phenomenon. It's only been around for maybe 150 years, and it's really been only since the end of the World War II that it really became such a predominant social and government institution. And the context of that is historically crime has always been something that has been dealt with by communities, either by private citizens between one another, between the offender and the victim, or dealt with at a community level. And it's really only since the end of the Second World War that the government or the state has really taken over or taken control of how society deals with crime. And it's been in the last few years that we've recognized the limitations of the criminal justice system, and as a result are acknowledging the crucial role that non-governmental organizations play in crime control, primarily outside the criminal justice system. And of course, we're referring to crime prevention, restorative justice, and other community-based approaches to crime control. So today, while the criminal justice system dominates crime control in this country, communities and private citizens, private organizations and entities are also very important in a crime prevention role in partnership with governments and the state. So it's really this combination of a state-run criminal justice system combined with a more community-based crime prevention approach that we truly can comprehensively address crime in this country. Within this course, we're primarily going to focus on the criminal justice system, but at the very end of the course and the last module, so we're going to talk about alternatives to the criminal justice system, in particular crime prevention. So as I mentioned, crime traditionally was considered a private matter between private individuals, in particular the victim and the offender. So during the pre-industrial era in the United Kingdom, this is primarily before the 19th century, 18th, 19th centuries, the state, the government, the sovereign did not generally become involved in criminal matters. The only criminal matters that they actually became involved with were ones that threatened the state. So revolutionaries, those trying to overthrow the government. And in these cases, the government did respond to these offenders, these political offenders in many cases. And what characterized justice in the pre-industrial days was really a brutal system of arbitrary arrest, arbitrary detention, and brutal, bloody public punishment. This is the main way that the state exercised its role in order maintenance or formal social control. But outside of this kind of political criminal justice system, much crime and crime control was the responsibility of communities, of villages. And these small villages regulated themselves through what we call informal social control. So if state government approach to crime control is one of formal social control, then villages exercised this informal social control, which basically means that there were commonly accepted values and norms of what was acceptable and unacceptable behavior. And when somebody crossed that line into unacceptable behavior, then it was dealt with through the community. And this could have been brutal punishment as well. And it included, again, perhaps negotiations, perhaps restitution. It could include jailings as well. But in general, the central government in the UK, the sovereign, did not get involved in small crimes, even as violent as they may have been in small villages in pre-industrial areas. They've primarily focused on political crimes, radicals, revolutionaries, and what characterized the criminal justice system exercised by the state was a bloody, brutal, punitive-based system, which included public hangings, public executions, and these public shows of punishment were intentional because it was meant to instill fear in the public. It was meant as a system of deterrence, to deter individuals and groups from trying to overthrow the state. So we don't have public punishment in Canada anymore, but we still have the concept of deterrence, the use of punishment as deterrence. So some of these brutal yet utilitarian or instrumental approaches to the criminal justice system still continue in Canada to this day. The criminal justice system as we know it today really began to evolve under Henry II around the 12th century or so. Henry was a very progressive ruler, and under pressure from the lords and other influential individuals within the UK, there was pressure to start having a more just system and one that could help address crime in the UK, but also to ensure that there was uniformity throughout the country. Because at the time, because criminal justice and crime control was village by village, it was often very arbitrary and very ununiform, if we can use that term, throughout the country. It varied and there was no consistency. And so Henry II not only sought to create uniformity, but at the same time, he was trying to establish the power of the sovereign and of the central government. And the criminal justice system was one way to establish that power. And again, even today in the criminal justice system, the state government has tremendous amount of power because of their control over the criminal justice systems. It was Henry where we saw the common law tradition begin. He first started appointing judges, what we call circuit judges, a term still used today, who traveled around the countryside and throughout London and villages, basically to hear cases. And all of these circuit court judges would get together and they would share decisions. They would tell other judges how they made the decision and why. And this was the foundation for the jurisprudence or precedent basis or common law system, where decisions made by courts were often replicated or used as a basis for decisions by other courts. At the same time, local traditions were being supplanted by laws and by the decisions of the judges. And importantly, crimes that took place between the victim and the offender were no longer considered a private matter. They were now considered a crime against the state. And this is a very significant transformation, because today, as we well know, if you commit a crime against someone, that's no longer a private matter between you and the victim. It's now between you and the government. So it's the government that prosecutes you. It's the government that punishes you. And really, there is no civil relationship between the offender and the victim anymore. It's now between the offender and the state. And as we talked about earlier, the victim tends to have a fairly minor role. But the important point here is that under Henry II, crimes were now no longer a private matter between the victim and the offender. It was now a public matter between the state and the offender. So crimes were now not crimes against individual private citizens, it was crimes against the state. And that continues to this day. So under Henry II, you had the appointment of circuit court judges, you had the beginnings of the common law system, you had greater uniformity in laws and crime control in the country, you had increased power of the state to establish maintenance and to establish order in society and to address crime. And finally, what you had was this whole idea that crimes were now no longer between two individual private actors, but between the offender and the state, and it was the responsibility of the state to address that crime through law enforcement and criminal trials and punishment. Perhaps the next most important development in the history of the criminal justice system during the pre-industrial era was the Magna Carta, which came into force in 1215. The Magna Carta is considered one of the most important documents, legal documents, state documents in the history of Western civilization, because it was one of the first documents to spell out the rights of individual citizens. And many of these rights were in relation to the criminal justice system. And so the Magna Carta basically established the first sort of rights of defendants and individuals within society. And this included the right to property, and at least the right that they were not dispossessed of the property except by lawful judgment of the land of the peers by the law. So it started to establish a legal basis upon which society could be governed. So no longer could the sovereign or the lords come in and simply take away your possessions arbitrarily. They now, if they did so, would have to go through certain legal avenues. And if this happened, then the victim could also always appeal or sue or undertake some kind of civil recourse. But the importance of the Magna Carta really was it established the rights of individuals. And of course, many of these rights were established in relation to the government and the evolving criminal justice system. Another important piece of legislation was the Statute of Winchester, which was enacted in 1285. And what this did was establish legally and formally a neighborhood-based system of surveillance and policing. And basically what it did was it required all villages to enact a system of policing. And so these were some of the first informal yet increasingly formalized systems of policing and law enforcement within villages. So while at first these were informal systems where every individual or every adult male, I should say, was responsible for surveillance and crime control in the community. Increasingly what you had were the wealthy villagers paying other villagers to assume their responsibilities. So you now had the evolution of paid policemen. They weren't policemen per se, but they were eventually called constables. But the importance of the Statute of Winchester was it really established the critical role that communities and villages would play in crime control. And again, this today plays out in the importance of municipal policing, but also the importance of communities and private citizens in that community to maintain order and justice within that particular community. Another important development in the history of the criminal justice system in Great Britain and throughout Europe was the advent of what today we call the classical school of criminology. Basically what you had were a number of reformers that started to question and critique the system of punishment that was in place within the UK and other European countries. Punishment meted out by the state was still very arbitrary, very cruel. The prison systems were extremely antiquated and cruel. And what these reformers wanted was basically trying to develop a rational and just system of criminal justice in particular, and so they wanted to put the justice in criminal justice. So they were very important in bringing about issues such as due process, so that people are accused of crimes were given certain rights as they were processed through the system. And they also advocated for more humane forms of punishment. So the kind of torture and brutal punitive measures that were taken against accused were basically slowly replaced with more humane forms of punishment. And so the argument of the reformers was that punishment must not be arbitrary, because arbitrariness really led to abuses by the states. And in the same time, it did not create a kind of system that people could understand and follow. Because it was arbitrary, you never knew what you were going to do to get in trouble. There were no set uniform rules to follow. So what the reformers argued was that they needed, what the system needed was a systematic set of rules that apply to everybody and in which everybody understood the difference between right and wrong. And so the punishment and the criminal justice system was conceptualized not as an arbitrary system, but a rational, systematic means of delivering justice that everybody could understand. And by being efficient and being systematic and being universal, people would understand the system better. They would understand the difference between right and wrong. And you would have a coherent social control system in place. And finally, what is really important about these reformers was they argued that the punishment had to fit the crime. And this was not only for the sake of humane forms of punishment for offenders, but it also fit into an overall system of deterrence. So the argument was that if punishment was delivered in a uniform way and the punishment fit the crime, then there would be a greater sense of deterrence. Because if you had violent offenders that were committing violent offenses and they understood that their punishment was going to be death or lifelong punishment, then the argument was that this was going to deter them. But at the same time, there had to be justice, so you couldn't have systems of death or punitive punishment for someone who perhaps stole a loaf of bread. That simply wasn't just. So what you saw with the reformers was an advocation for a more humane system, but one at the same time that could serve as deterrence. They didn't argue against punishment. They argued that punishment had a place to play in the criminal justice system and deterrence. They were just arguing for one that was logical and systematic and coherent, and at the same time that was just. So the reformers of the 18th and 19th century established a very important foundation upon which criminal justice systems operated for years to come. And we still see the coherent, uniform, just system of punishment within our system today. Another very important development in the history of the criminal justice system in the UK and throughout the Western world was the creation of the first formal police force, or the first formal police service, which was the London Metropolitan Police Force. And the London Metropolitan Police Force basically came about because London was becoming more complex, it was becoming more urban, more people were living there, it was bigger, and maintaining order within the city was increasingly difficult to do based on the watch and ward system, the system created by the Statute of Westchester, where private citizens were responsible for maintaining justice and order and crime control. So through the Home Office, through Sir Robert Peel, he set about creating the first major police force in the world, the first modern police force. And this was basically to again, keep up with the increasing growth of London and the need for a permanent force to address crime in society. So in 1829, Sir Robert Peel created the London Metropolitan Police Force, and he had really he had 10 guiding principles, but two that many see as the most important. was his line that the public, or the police are the public and the public are the police. And what this meant was, even though we're creating special positions, constables to enforce the law enforcement, policing, crime control are still the purview or the responsibility of everybody in society. So simply the police are just people who are hired from the community to enforce the law. They're still part of the community, and so the community is still an important part of crime control. They're just an extension of the public. And the second principle that Peel emphasized was that the best way to police societies and maintain order and to keep a crime within control was to prevent crime from happening, the prevention of crime. And for many years following the creation of the Metro Police, we sort of lost sight of that, and police became increasingly reactive. But we're now returning to this concept that the best way to control crime is to prevent crime and criminal behavior from emerging in the first place. But obviously the London Metropolitan Police was important because following their creation, you saw the creation of police forces throughout the Western world, Canada, the United States, throughout Europe. And this obviously was significant because it represented yet another step of the government or the state to monopolize crime control, to take away the responsibility of crime control from the public to the state. Another important development in the 19th century was the rise of positivism, which basically means the scientific methods. During the 17th, particularly 18th, 19th century, we saw the rise of Enlightenment. Enlightenment was a revolutionary way of thinking and looking at the world that replaced religion and philosophy and the occult as ways of understanding the world with a more scientific method. And so crime and criminal behavior became subject to scientific methods of study. And this increased our understanding of crime. It increased our understanding of criminal behavior. And a discipline that we now know as criminology began to evolve, strictly focused on crime and the cause of criminal behavior. So obviously law enforcement and the justice system began to be affected by this body of knowledge, this growing body of knowledge about crime and how to address crime. And some of the early developments in this early years of criminology was that crime or criminal behavior was the result of the pathology of the individual. Today we understand it more as that individuals aren't pathological. Criminal behavior tends to be rooted in the social environment of kids and youth, especially those that come from very negative social environments. But back then, the argument was that it was the individual that was pathological. They were born innately criminal or innately violent. But what's important about this perspective was that if the individual was pathological, then it gave hope that they could be rehabilitated, that they could be treated, and they can be cured of this sickness or this illness. Some people know because they were just genetically programmed to be criminal, but others, it was felt, came from bad environments or suffered, say, from mental or cognitive problems, and therefore they could be treated. And this brought in the religious orders because they were very much in saving souls, and criminals were people that they can save. So with the early advent of the scientific method in this field, the early foundation of criminology, those within the reform movement used this discipline as a means to further promote this reform agenda. So promote rehabilitation, promote treatment, and these aspects increasingly became a part of the criminal justice system. And today, obviously rehabilitation and treatment are important parts of the criminal justice system. So positivism, the reformers gave rise to rehabilitation and treatment. So the criminal justice system was no longer just about punishment. It was about rehabilitation and treatment as well. And that very much can be attributed to the early years of the discipline of criminology. We'll now jump ahead a few decades to another significant period in the history of the criminal justice system in Europe and in North America, and that was in the post-war period. And in particular, it was the rise of the welfare state. Basically, what the welfare state means is a government or a state that feels obliged to take care of its citizens. And it really was very much rooted in the English Labour Party. The Labour Party was a left-leaning party that emerged after World War II and really saw the state as a principal player in helping people, in helping the welfare of people. And so in the post-war era, what you saw was a really incredible expansion of government and of the welfare state in particular. And basically those who advocated for the welfare state said to people that we will take care of all your needs. We'll help you find jobs. If you don't have a job, we'll provide you with unemployment insurance. We'll provide you with health care. We will give you old age security benefits, and we will make sure that you live in a safe and secure society. We will take care of crime. And so with the rise of the welfare state, what you saw again was the government taking more and more control over crime control, over formal social control, as opposed to the history in which communities and private citizens controlled crime through more informal mechanisms. So in short, what you had was the state becoming more and more dominant in crime control. And as a result, you saw the incredible rise and expansion of the criminal justice system as society's main institution to address crime. So the police, the courts, the government in general were now the main institutions with responsibility over law enforcement and crime control. So the argument is that the state, during this rise of the welfare approach to governance, really usurped or undermined the historical control that private citizens played in crime control. So now you had the advent of the criminal justice system really as the dominant player in crime control, and that continues to this day today. By the 1960s and early 1970s, one saw a important development in the more contemporary history of the criminal justice system, and that was the exponential, precipitous rise in the crime rate and fear of crime in the United States and Canada. Within the US and in Canada to some extent, there was a significant rise in the crime rate starting in the early 1960s, which continued in the 70s and 80s. And that basically was due to demographics, in particular young baby boom men, those born in late 40s, early 50s, are now entering their crime-prone years. And so you had this very large cohort of men basically now getting into crime, and so it began to decline in the 90s, the crime rate, and that was mostly because, again, you had a precipitous decline in the number of young men in their crime-prone years. But the repercussions of the 60s and 70s was that not only did you have an increase in the rate of crime, but you had a real increase in fear of crime. Many people were really losing confidence in the criminal justice system. It was now really becoming clear that this whole notion that somehow the state can take control and take care of our crime control needs was now really seriously being questioned, and their realization that the state really could not maintain order and keep the crime rate low without a strong buy-in and participation by the community. So what you had at the end of the 60s and the early 70s and in the 80s was a real loss of confidence in the criminal justice system, and a realization that the criminal justice system and the government in particular was very limited in what it can do to address crime. And so what you saw at this time was a loss of confidence in the criminal justice system and a reinvigoration of crime prevention and community policing. In particular, the importance of the community in controlling crime and preventing crime in particular, and the importance of the police and other criminal justice agencies and working with the public. So what you saw now was the pendulum swinging back from the extreme, which was the state would take care of all our crime control needs, and now it's back to the middle, where basically was we need both the government and the communities, private citizens, private actors to work together to address crime control. So while crime control still is primarily carried out by government in this today, even today, there was a significant increase in the idea of crime prevention and the discipline of crime prevention. And in the 70s, 80s, and 90s, you saw a significant increase in crime prevention programs and a real buy-in by police and a community policing, which is very much predicated on police partnerships with the community. I have not discussed in great depth the history of the criminal justice system in Canada. One of your required readings for this module is quite good at detailing that, but I will discuss one extremely significant development that had incredible repercussions for the criminal justice system, and that was the introduction of the Canadian Charter of Rights and Freedoms in 1982. It can be argued that there was no institution in Canada that was more impacted by the Charter than the Canadian criminal justice system. And it makes sense because what the Charter was about was protecting Canadians from the government. It was protecting our rights. It was codifying into law our rights as citizen. And basically when you are protecting the rights of citizens, you're basically protecting them from the government, so the government does not infringe upon our rights. And of course, what institution has potential to infringe on our rights more than the criminal justice system, and police in particular? So you will see within the Charter a number of significant sections that are directly relevant to the Canadian criminal justice system. And we're going to talk about that more when we talk about criminal law. But many people refer to the history of the criminal justice system and the history of policing in two periods. You had the pre-charter period and the post-charter period. And the post-charter period was significant because it really codified into law and reinforced the fundamental importance of justice in our justice system. And so by doing so, it very much protected the rights of defendants. It protected the rights of all citizens against arbitrary search and seizure, arbitrary arrest. It guaranteed our right to remain silent. It guaranteed our right to counsel and to a timely trial. And so the Charter had significant impact on curtailing the powers of the state and the police. And so that had a very significant impact on criminal justice system. I'd now like to shift gears and talk a bit about some of the fundamental principles, values, and tenets of the Canadian criminal justice system. Let's first talk about the basic role or purpose or goals of the Canadian criminal justice system. And we touched on this a bit in the last module, where we provided an overview of the system. But the basic premise or basic role of the Canadian criminal justice system within society is to maintain order, and that's done so through crime control. And so what you have in the Canadian criminal justice system is a state-run form of formal social control. And again, this is held in contrast to what's often called informal social control. Informal social control is where individuals as a community, whether it's within a neighborhood or a larger society, have certain unwritten norms and values and principles that they enforce almost in a purely unconscious manner that helps to maintain order within society. And the argument is that no matter how much formal social control you have in society, if that informal social control is missing, if people are not willing to agree to sort of common standards, and the whole system falls apart. And so while the formal social control system is very important, what's really critical to crime control and order maintenance in any society is informal social control, the ability and the willingness of people to maintain certain standards that everyone agrees upon. But given that we're talking about the Canadian criminal justice system, we're really talking about a system of formal social control. And what we mean by formal social control is social control that's exercised by the state through laws and legislation, through formal institutions like the police or the court system. And basically, it's created to maintain order, to maintain a type of control, to establish the norms for behavior, and also to establish punishment and other sanctions if people transgress that established behavior. And again, a lot of formal social control is based on the norms and values that are critical to informal social control. They're just both of them are enforced a little differently. What's also critical when you talk about the criminal justice system and formal social control, it's basically a social contract between citizens and government. In many respects, the citizens are giving up complete freedom because the laws that are put in place obviously restrict our freedom. We can't do anything we want. We can't behave any way we want to. And in return, what we give to the government is their power to enforce the laws and the norms and principles that we supposedly subscribe to. So there's a trade-off in the social contract that if we basically as citizens say that, we'll be good and we'll behave properly, and if we don't, then you as a state have the right to step in and enforce that as long as you respect our rights. That's the basis of a social contract. And again, obviously the crime control and order maintenance and this whole social contract is premised on the enforcement of laws and regulations and the implementation of institutions and branches of these institutions to ensure that this social contract is enforced. Because if the federal government or any government did not put forth a credible system to enforce these laws and to enforce its side of the social contract, then it would have no credibility, and that would be very much undermining the whole formal social control system. So the criminal justice system, broadly speaking, is one aspect that the government has to maintain order in society, to control society, and in particular to control people's behaviors. And so with this slide, I'd just like to once again reinforce the differences between formal and informal social control, because these are two diametrically opposed but at the same time complementary ways to ensure order, to reinforce social control, and to control crime in any society. And again, the formal social control is characterized by being explicit, it's written, it's codified in laws and legislation, it's regulations that are enforced through government agencies and institutions, and it's really personified by the criminal justice system. Informal social control is carried out by citizens, by communities, and these are implicit, unwritten, commonly accepted norms, standards, conventions that are subtly enforced by people, not necessarily by the law. And what's important about informal social control is that this is the foundation of crime prevention. This is the foundation of programs like Block Watch and citizen patrols. But again, even in the absence of these formal programs, informal social control is meant to maintain order simply by conveying to people in that environment what behavior is accepted and what behavior is unaccepted. And in neighborhoods that have a low crime rate, you also tend to find very strong rates of informal social control. That is, people who are willing to quote unquote defend their neighborhood, whether that is calling the police if they see something suspicious, perhaps confronting someone, perhaps even lobbying government to enact certain measures like putting in speed bumps or road signs in their neighborhoods. So the two are complementary, and the important point here is that obviously the criminal justice system is an example, if not a personification, of formal social control, while crime prevention is an example of informal social control. The two work best when they work together in a cooperative, conciliatory fashion. And most importantly, the criminal justice system, those in charge of formal social control, have to take informal social control seriously and have to be able to give up power and resources to those in the communities because informal social control is an absolutely fundamental way to maintain order and crime control in any society. I'd like to conclude this particular module by focusing on the fundamental philosophical tenets of the Canadian criminal justice system, and any criminal justice system for that matter. And we've already touched upon these briefly in the previous model, but the six are justice, punishment, deterrence, rehabilitation, reintegration, and protection. As we go through each of these principles, I'm going to use roughly the same template to describe and analyze each, and that is to provide an overview of this concept, its implications for criminal law or criminal sanctions or the criminal justice system in particular, and also talk about what are the main influences that this principle has on the criminal justice system and the Canadian criminal justice system in particular. So we'll start with justice because that is considered in Canada the most important principle within the Canadian criminal justice system. And what justice basically means is that there's fairness for all involved, in particular defendants, that human rights are respected and that individual dignity is respected. A fundamental aspect of justice is that the laws apply to everyone and that everyone is treated equally. And as importantly, justice is about ensuring that due process is respected. So due process is sacrosanct in the broader context of justice. And some of the key aspects of due justice, some of the key aspects of due process and justice is that the accused is innocent until proven guilty, that the system must respect the rights of the accused, and that the accused and all of us have to be protected from arbitrary decisions by the state. As I said, the justice branch or justice component of the criminal justice system is really backed up by the Charter of Rights and Freedoms. It's the Charter of Rights and Freedoms that it really ensures justice or oversees the justice in the criminal justice system. So when you're looking at criminal sanctions, the justice philosophy emphasizes that all offenders have to be punished justly, that the punishment must fit the crime. Increasingly as well, there's an emphasis on alternative flexible sanctions for offenders, which basically means that each offender has to be treated uniquely and that the sanctions that are applied to some may not necessarily be appropriate for others or just for others. And so there's increased emphasis in Canada in looking at alternatives to imprisonment and even alternatives to the criminal justice system so that offenders are processed through alternative systems, whether it's restorative justice or drug courts, which we'll talk about later in the year. So the influence of the justice philosophy on the criminal justice system is it really helps society reach its highest ideals, at least as far as human rights is concerned. The Charter of Rights guarantees the justice model in society, and it really has made the Canadian criminal justice system one of the most respected systems in the world. It's certainly not free of abuse and bias and discrimination, and there certainly has been plenty of cases where injustice has been carried out. But at the very least, we know that in our society, justice is taken very seriously in this country. Civil and human rights are taken very seriously, and we can see that simply by how the rights of police and other criminal justice agencies, their powers have been curtailed in recent years due to the Charter. The critique that one may have of the justice is that the system has bent over backwards to protect the defendant, to protect the rights of the defendant at the expense of victims and the collective security of society as a whole. And so in particular, those on the right of the political spectrum, conservatives, like to argue that we coddle criminals, that they have too many rights, and because they have so many rights, this undermines our collective security. And this is certainly an important issue that you should think about and debate, and especially as you go through this course, is again this great challenge that the criminal justice system faces on balancing the right of defendants with the collective security of society. I think it's pretty obvious to say that punishment is a critical aspect of the criminal justice system. It's one of the earliest of the tenets of the criminal justice system, and one that has characterizes any criminal justice system. It really basically stems from the idea that if your behavior is out of line with the norms and values of society and of the laws created by government, then you have to be punished. But it's punishment for the sake of punishment. You know, if you get your hand caught in the cookie jar, you should be punished. But at the same time, punishment serves another goal, another means to an end, and that is deterrence. So one of the reasons we have punishment is to deter other people from committing similar behavior. And I'll talk a bit about deterrence in an upcoming slide. The obvious implication of punishment for the criminal sanctions is that it makes the criminal justice system a punitive system. You can measure a criminal justice system by how punitive or punishment based it is. The American system for years is far more punitive than Canada. Punishment has been a much more important characteristic than in the Canadian system, where we tend to put more emphasis on justice and reintegration. But the importance of punishment, as our research tells us, is that it has to be prompt, it has to be certain, and it has to be uniformly applicable to everybody. And this gets back to the justice idea of the criminal justice system. But punishment can't be arbitrary, and it certainly can't apply to some and not to others. And what the research shows is that punishment in general is not going to have a significant effect on crime rates. If that's the case, then the United States would be the safest country in the world. It has very significant punishment, including capital punishment, but yet it still has a very high crime rate. So the causal connection between punishment and deterrence and crime rates is very tenuous. So punishment in itself is not going to be a significant factor in crime control or even deterrence. But obviously it's a fundamental part of the criminal justice system, and it's always going to be a part of the system. As I mentioned in the previous slide, deterrence is a very important part of the criminal justice system. The whole idea of social control, formal social control, is very much based on the concept of deterrence. In other words, the idea is that if you have strong systems in place, if you have the prospect of punishment in place, then this is going to deter people from behaving badly, from committing crimes. And so deterrence is very much rooted in punishment. The argument is that if you have punishment in place, then that's going to deter people from doing the crime or from behaving badly. So the whole social control system is very much based on deterrence. The underlying philosophy or theoretical foundation is that people are rational and they have free will. Therefore, if we can scare them through punishment, then we can deter them from behaving badly. So in other words, people act rationally, and if they act rationally, then they'll want to avoid being punished, and if they're going to want to avoid being punished, they're going to avoid doing bad things, doing crimes. It's sort of a negative perspective on human behavior. It's basically arguing that we're inherently bad, and the only way that we can stay in line is that we're threatened with punishment. But what the research shows is that you need a certain amount of punishment to work as a deterrent, but it's not the scope of the punishment, it's how quickly it's delivered. In other words, the general public and even with offenders, the research has shown that if you have the prospect of being caught as an offender quickly after you commit a crime, then that serves much more as a deterrent than the severity of the punishment. So in other words, even if you had capital punishment in your country, in your jurisdiction, that doesn't necessarily mean it's going to deter people from committing murder. And again, the United States is a great example. Many of the states still have capital punishment on the books, yet these very same states have some of the highest murder rates, not only in the United States, but in the world. So as far as for deterrence to work, punishment has to be swift, and that's the most important principle as far as deterring criminal offenders and the general public is concerned. Severity and the whole idea of public punishment is something that's not borne out by the research. There are still countries that do have public hangings and public executions. But that doesn't necessarily mean that people are going to be deterred from doing crimes because they're actually witnessing the punishment. So what's interesting about the concept of deterrence is basically arguing that the criminal justice system can actually prevent crime. Punishment and the criminal justice system in general can prevent crime by deterring people from engaging in criminal acts. But again, deterrence is a very controversial concept. Many researchers and others argue that people are not really deterred from crime because of swift punishment. They're deterred from crime simply because they have the moral obligations, the commitment to their social contract with others in society not to behave badly. And so the way to ensure a low crime in any society is not necessarily through punishment and trying to deter people, but it's from fostering people's connections and their bonds to society, because the stronger bonds they have to society and the norms and values of society, the more they're going to respect those values and respect those laws. And that truly is what helps keep a crime rate low in any country. Protection is obviously a critical aspect of the criminal justice system. Basically, the government, through the criminal justice system, assumes responsibility for protecting society from bad people, from criminals and offenders. And this is part of the social contract. In other words, we give government the right to enforce laws and to control crime, and we give them extraordinary powers to do so. And in turn, we give up some of our rights, and we give up our sort of liberty to do anything we want. And if we do so, and if we give the government these powers, then they're obligated to protect us. They basically say, we will protect you if you give us these powers and these responsibilities. So protection is a critical part. And it's basically protecting society, protecting individuals and society as a whole from crime and from criminal offenders. And protection is done through police, through incarceration, and through rehabilitation of offenders as well. An extreme example of protection by the criminal justice system in Canada is the danger offender status. The government, federal government, has the power to label a convicted felon a dangerous offender, and therefore they can keep him or her incarcerated for an indefinite period of time. So even after, say, their life sentence has been used up, if I can use that term, if they've passed their life sentence, the government can still keep them in jail. And dangerous offender status has been applied to serial killers like Clifford Olson, and also to Paul Bernardo, for example. So that's an extreme example of how the criminal justice system is meant to protect us from dangerous offenders. But obviously, the system is there not just to catch the offenders and to deter them from committing crimes, but to protect society from these people and from widespread law breaking. A fairly recent emphasis of most criminal justice systems has been this concept of rehabilitation. I say recent because it's really one that follows the original tenets of the criminal justice system, which was punishment and deterrence. Rehabilitation, as I mentioned in previous slides, is basically started with the reformers in the 18th and 19th century and really took off in the 1950s throughout the world. And the argument is that it's not enough for the government or for the criminal justice system to punish and deter offenders and protect society. We also need to try to rehabilitate or treat those offenders. And that is a goal in and of itself, but it's also seen as a goal to protect society. So instead of just simply locking someone away forever, which in many cases we can't do, but if we can reform them or rehabilitate them or treat them, then they will refrain from criminal offending in the future. So rehabilitation is very much as important to society's protection as punishment is. So rehabilitation is basically trying to treat the cause of criminal behavior. Its goal is to reduce recidivism. Its goal is to protect society. And there's a fundamental assumption of rehabilitation, and that is that that no one individual is inherently pathological or is inherently violent or dangerous. There's the idea that many offenders can be quote unquote reformed or rehabilitated through the proper treatment. So in relation to punishment, rehabilitation is the exact opposite. It's often non-punitive, and it's important that offenders get the type of rehabilitation and treatment they need in the community. Many correctional systems are geared towards rehabilitation. However, only a very small percentage of correctional resources are dedicated to programs to help offenders. The vast majority goes into capital costs, housing and food and prison guard salaries and the bureaucracy in the criminal justice system. So very little money actually goes into rehabilitation of offenders within the correctional system. That's why it's so important that offenders be reintegrated back into the community, back into society, where rehabilitation and treatment and the promotion of pro-social behaviors among offenders works the best. Which brings us to our last principle of the Canadian criminal justice system, which is reintegration. And this is one that tends to be missing from many principles when others talk about the Canadian criminal justice system. And I include this here again because it really is a fundamental aspect of the Canadian criminal justice system. Once an offender enters the criminal justice system, especially if they've been convicted of an offense, everything revolves around getting them back into the community, getting them back into society where they can get the treatment they may need, where they can engage in pro-social behavior, where they can get a job, be with their family, be with their friends. And again, the idea is to get them back into society, and that's what's best for their quote-unquote rehabilitation. It's a recognition that the correction systems, is more adept at producing or reinforcing criminal behavior than stopping it. So everything is about getting the offender back into society, and that's why probation is the most frequently handed out sentence within the Canadian criminal justice system. More offenders are sentenced to probation, so time in the community, than all other sentences combined. And so judges and the system in general recognize that reintegration, getting offenders back in the community or ex-offenders back in the community is absolutely critical. And so it very much operates with the whole idea of rehabilitation. So the whole reintegration concept is about getting offenders back in society, back in their communities. It very much works in tandem with rehabilitation because rehabilitation best occurs within civil society. And the premise of reintegration, or one of the premises, is that only the most serious offenders should be incarcerated. So it's really only a small minority of criminal offenders should actually be punished through jail sentences. And this is again reflected in statistics that really it's a very small minority of criminal offenders in this country that are chronic violent offenders who deserve incarceration. So reintegration is a critical concept in the Canadian criminal justice system. It emphasizes it's a critical aspect of probation and parole. It's a critical aspect of alternative sanctions to prison. So judges handing out sentences that avoid prison. Again, it's there to promote rehabilitation and pro-social behavior. And it's really to promote the connections of the ex-offender to society, civil society, and the community. So in Canada, it's a very, very important principle. But again, the question now is whether or not what's best for the offender is best for society, because a lot of people argue that many offenders should go to jail, that they should have longer sentences, that they shouldn't have parole. And that's a valid argument, but it's not backed up by research, which shows that offenders released into the community through probation or parole actually have a lower recidivism rate than offenders that have spent time in jail. Again, the research is not definitive on that, but certainly the Conservative government in Ottawa sees things a little differently. They believe that for certain offenses, offenders should not be released in the community, that they should go to jail, and that for certain offenses there should be minimum prison sentences. And again, so the Conservatives in some respects are rejecting, or at least uh, um, trying to place more punitive measures in the Canadian criminal justice system and place less emphasis on this reintegration aspect. We're going to end this particular module looking at perhaps the most important piece of legislation in Canada, and one that has significant implications for the criminal justice system, and that is the Canadian Charter of Rights and Freedoms. As we've touched on, the Canadian Charter is the primary law of the land in Canada. With very limited restrictions, it guarantees fundamental freedoms, legal rights, and equality rights for all people in Canada, which includes citizens and non-citizens, including those accused of crimes. So specifically, the Charter provides protection for individuals and ensures fairness during legal proceedings. All of the components of the criminal justice system have to operate in such a way as not to violate the rights guaranteed in the Charter. So what are some of these rights that are in the Charter? Life, liberty, and security of person, no unreasonable search and seizure, no arbitrary detention or imprisonment. You have the right to remain silent if you're arrested or detained by a police officer. You must be informed of your charges. You are presumed innocent until proven guilty by a court of law. You have the right to legal counsel. You have the right to bail. You have the right to a speedy trial. You have the right to a fair and public hearing. And you have the right to no cruel or unusual or arbitrary punishment. So as you can see here, a number of the basic tenets of the criminal justice system have direct implications for the Canadian criminal justice system. And in many respects, as I mentioned before, the Charter of Rights was very much geared towards ensuring that the rights of Canadians were not infringed upon by police or other agents of the criminal justice system. So again, there's no institution in Canada that's perhaps been more affected by the Charter than the criminal justice system. Now, as I mentioned in the previous module, the Supreme Court is the final arbiter of whether or not particular actions of the police or other criminal justice agency actually abrogates the rights under the Canadian Charter of Rights and Freedoms. So this, in addition to the rights that are laid out in the Charter, the Supreme Court has made a number of significant court decisions that has interpreted and even expanded the rights of individuals and defendants vis-a-vis the criminal justice system. So there's been numerous decisions made. I'll just touch on four. One of the most significant is what's called disclosure, or the right to disclosure. And that basically, the Supreme Court argues that the Crown or the Crown prosecutor must make all evidence available to defense counsel. And this was never the case before. The case was always that the Crown and the police would often withhold evidence that they had. And the Supreme Court found that this abrogated the rights of defendants, especially when the police withheld evidence that may prove the defendant to be innocent. And so now you have what's called disclosure, and disclosure is kind of a dirty word for police, simply because it's a very time-consuming process to release all the documents that a police and the Crown have to defense counsel. But again, the court has ruled that it's the right of defendants to have to see all the evidence that police have against them. The Supreme Court has ruled that the defendant, the defendant has the right to question the accuser. And basically that means that, let's say in a sexual assault case, even in a case that extreme, that the victim can't hide from the defense counsel. In other words, the defense counsel can put the victim on the stand and can question him or her, as part of the defense of the defendant. And again, this is very controversial, but again, it's an example of where the rights of the defendant in many instances trump the rights of the victim. And again, it sort of shows how critical and how important the rights of defendants are within the broad spectrum of the criminal justice system. There's many other decisions. Again, was a decision with respect to the insanity clause, and if someone is found not guilty by reason of insanity, their detention has to be reviewed every 12 months, and numerous decisions on the ability of police to search and seize property within the context of a criminal charge. And a lot of court decisions have revolved around the power of police to search and their ability to enter a premise, if what constitutes probable cause. For example, if they smell marijuana coming from a window, does that give them probable cause to enter the premises? So the important thing is that not only do we have the Charter of Rights and Freedoms, which establishes fundamental rights, but we have a Supreme Court whose job is basically to interpret the Charter, and in many cases they have very much backed up the fundamental rights of defendants and of citizens vis-a-vis the criminal justice system. And again, many argue that this has been at the expense of the collective security of society, and that's a decision you have to make, whether the Supreme Court is perhaps bent over backwards to protect the defendant at the cost of security to the country as a whole, as some critics would charge. So just by way of conclusion, it's important to recognize that the criminal justice system is a dynamic, ever-changing institution. And when we look at the principles of the criminal justice system, these are not without controversy. And as a liberal arts student, as someone who is trying to enhance your critical thinking skills and analytical thinking skills, there's certainly a number of questions that you should ask and you should think about as far as the philosophical tenets of the criminal justice system. And again, there's no right or wrong answer to these. It's the answers often depend on your moral perspective and political ideology. But some questions you should think about as far as the justice component is concerned is, are we placing too much emphasis on the individual rights of offenders at the expense of the security of collective society? As far as deterrence is concerned, the question that's often asked is, does harsh punishment or punishment at all actually serve as a deterrent for the general public and specific offenders? And more importantly, does capital punishment really serve as a deterrent? And when we come to the question of punishment, there's this question that many critics have been asking, and are we simply too soft on criminals? Again, this gets back to this whole idea of, we're defending the rights of defendants, and we're emphasizing justice and reintegration, and are we simply being too soft? Do we need to assume a more punitive stance? Obviously, the federal government, the conservative government, believes we are too soft, and that's why it has implemented a number of measures to make the system more punitive, including mandatory minimum sentences. The question of rehabilitation is a perennial one. Can we actually rehabilitate chronic offenders? And this is a very general question. The answer obviously lies in, we have to take each individual offender as an individual. They're each unique people that are that can be susceptible to rehabilitation, and some are not. But does it actually work? And if it does, what are the circumstances and what are the measures and what are the techniques that best work? Finally, reintegration gets back to the question as well. If you've been charged with a crime, is it really just for you to be serving time in the community? And can we really rehabilitate offenders better in the community versus prisons? Why can we not put the resources in correctional institutions to rehabilitate offenders as opposed to having those resources within the community? So a number of questions that will help you think critically and analytically about the criminal justice system. And definitely you should reflect on the principles we've talked about, how they emanate from the history of the criminal justice system, and how the goals and purposes and tenets of the criminal justice system are very much influenced by history and the historical development in the UK. But you need to come to your own decision on what you see as the most important principles of the criminal justice system in order for it and for society to achieve its ultimate goal of crime control and order maintenance.